Okay, let's begin the session. I'm sharing the screen. My screen visible to everyone?
Yes, sir.
Okay, thank you. Okay, so procedure for grant of patent we have done. We yesterday learned that there is a patent which is granted. Okay, and when it is granted, it has to be recorded in a register of patent. Then we also learned that there will be a renewal fee. If you don't have a renewal fee paid, then it will cease to exist. Till this, we understood. It was in section 53, we talked about that there has to be a renewal fee needs to be paid within a prescribed period. The prescribed period is before the expiry of financial year. Before the expiry of a financial year for which you can say since renewal fee is paid in advance, then before the beginning of a financial year for which you are paying the beginning of the year for which you are paying the renewal fee. This is one thing. Now we will start with how, if, and this particular period can be extended for 6 months if you have requested earlier. So there will be a date on which this patent will cease to have effect. Then if patent ceases to have effect, what we will discuss about the restoration of that kind of a patent. And when it ceases to have effect, we call it as a lapsed patent. So I will go till that section, but before that, some general understanding of what register of patent is, how e-register looks like, and how the patent. I think I have discussed the patent office earlier. Few important clauses with respect to patent office we will discuss today also. Then comes first, there is a register of patent in which the details with respect to patent are recorded. Now, section 67 to 72 deals with the register of patent. Form is, it can be maintained in electronic form and it is under the control of management of controller of patents. It is available on website as e-register of patent. We will see e-register of patent within few minutes. Now, let's first, what are the details given? Grantee, patentee. What is the difference between grantee and patentee? Anyone can guess? Any guesses? What is the difference between a grantee and a patentee?
So grantee can be the applicant while the patentee is the person who has invented the invention.
Sorry? I could not hear you properly. Can you say again?
So the grantee is the person who might be, who's both applicant or who can be an applicant also or the inventor also. But the patentee is the person on whose name the patent has been registered. The inventor.
Okay. Let me ask you one question. Does inventor get the patent in India? Who can be the applicant? Come on, answer this. Who can be applicant?
So the inventor of the patent, inventor of the invention.
Okay, and anyone else?
Sir, I missed the question. Can you repeat that, sir?
See, my question is first question was, what is difference between grantee and patentee? The answer came that inventor, grantee can be an inventor or an applicant, but patentee is someone else, right?
No.
If I'm correct.
Sir, actually, grantee and patentee both person are the same.
Okay.
Like here that before that, after the grant, there are some sealing period was there. So that's me.
Okay. So,
Sir,
so
sir,
you are
grant.
saying grantee and patentee can be same.
Sir, when the patent is first time granted, then both are same. But after that time, if the grantee assigns the patent to someone else, then the patentee becomes the another person whom it is assigned.
Exactly. Now you have hit the nail. See, on the day of grant, who is getting the grant? The applicant is getting grant. Inventor has no role to play unless inventor is an applicant. So inventor can be applicant, his assignee can be applicant, or his legal representative can be an applicant. Anyone can be an applicant. Patent is granted to the applicant, not to true and first inventor. Their name is mentioned there, but they don't get right only because they are inventor. They should be named as an applicant to get the right. Okay. The first thing we understood, the patent is granted to the person who is filing the application. Now comes the applicant. When the patent is getting granted, this applicant, the time who is transcending this boundary, the application is turning into patent. On that day, whosoever was an applicant will turn into the grantee. These are the first patentee or first patent holder. You can, for just understanding that the people whom the grant is being made, they are considered as grantee. Now, at the time when the patent is granted, patent holders or patentee or grantee are the same person. However, after that, this can be assigned. Grantee has always and patentee has a right to assign. Suppose it was granted to an educational institute. Invention was done by some scientists in an educational institute. A, B, C were the scientists, but applicant was the educational institution. They got it. Now, the day the patent is granted, educational institution is a grantee as well as the patent holder or patentee. After that, if this educational institution assigns, that is, transfer his right of patent, the new assignee will become the patent holder and come on the register as a name, and his name will be registered as a patent holder. The earlier patent name of the patent holders will be only in the book that they were the grantees or the earlier patent holders. Now the present patent holder is the person whom the assignment has been done. So this is how the patents gets assigned, and the people whose name assignee get their name registered on the patents. That's why it talks about the details of the grantee as well as patentee. That subsequent patent holder's name will also be there. Notification in respect of assignment, transmissions of patent, license, and patent. Okay. Though I have repeated again and again, but just tell me, what is the assignment? What is different with assignment, transmission, and license? What happened?
Sir, assignment is probably assigning the ownership of the patent, and licensing is permission to use the patent, and transmission, sir, I am not aware of.
See, I'm again and again saying that there are only two modes in which any property is transferred. You all know that, right? If you are transferring, there are only two modes. One is, or we can say three modes. First is under an agreement, though that is called assignment. When you transfer and you go for a sale deed. What is that? That is transfer of your ownership. Same thing, assignment. Second part, by your father, by your parents, or by your grandfathers, how this is property is transferred, On the expiry of such family person, the legal heirs take that get it as by operation of law or under the will, that is succession, right? So when the patent are being transferred by operation of law, it is called transmission. Otherwise, if it is under agreement, it is called assignment. So the entire right is getting transferred. When you are not transferring the right, you are giving only the permission. It is called license. That is the license under the patent. So done assignment, transmission, and licensed under the patent. Then amendment, extension, and revocation of the patents will also come here. Then payment of renewal fee. Payment of renewal fee is, how much payment fee has been paid, whether it has been regularly paid or not. All those description will be there. Then particulars regarding proceeding under act before the controller or in courts. Any proceedings, whether in before controller or court, will also be recorded. Upon the grant of patent, the controller shall enter in the register of patent what? Name and address and nationality of the grantee as the patentee thereof, the title of the invention, including the categories to which the invention relates, the date of patent, date of grant thereof, and the address of service of the patentee. This register will be the prima facie evidence of any matter as required or authorized by Act to be entered therein. Please remember this section 72. You can get this as an MCQ, true and false question, or the 3 marker question in your paper. The register shall at all convenient times be open to inspection by the public, and certified copies of entry in register, the seal of patent office can be obtained after paying the prescribed fee. So it is open for inspection means you can inspect it. You want a certified copy, you can always ask for certified copies after paying the prescribed fee. Then third thing, copy of extract and register of patent or certified to be true copy under the hand of controller or any other officer whom the controller has authorized can issue this copy, extract, or anything. What will happen is these documents will be admissible in evidence in all legal proceeding. Remember, they has to be issued by under the hand of controller or duly authorized by controller to be admissible in evidence. If you download from the e-register directly, it is not admissible in evidence. It has to be with the seal of controller. He should authorize, he should issue it, then only it will be admissible in the legal procedure. Then 7, application for alteration of name, nationality, address as interview may be made to the controller, and controller may require. So if you are changing anything, whatever particular I have recorded in the register, you have to tell, you have to apply for me, request me, and on basis of your request, along with the proof, you have proof that this is the evidence because of which this alteration has to be done. Controller can change those entries. If a patentee makes a request in writing along with prescribed fee for entering an additional address for service in India and controller satisfies, he can also enter the additional address of service. Entries in the register for each patent are available public on the official website through e-register of the patent. Now, for rectification of register, anyone can apply. How rectification of register is done? Who can apply? Any person who is aggrieved. Aggrieved means who is concerned with who is troubled because of the wrong entry in the register. Where one can go for this? You can go in High Court. Then grounds are absence or omission from the register of any entry or any entry made in register without sufficient cause or any entry wrongly remaining or any error or defect in. Then you can go to High Court and get this rectified. Or you can apply for rectification notice to controller. It will be what happened when you have applied. Controller will be given a notice, hearing will be conducted by controller, order of rectification will be passed, and notice of rectification will be given, and controller will rectify the register. Just a minute. Give me a second. I have to just check 17. So this is how rectification can be done if you are taking the High Court. Now, Patent Office and its establishment. Patent Office and establishment, the Controller General of the Patent, I have already discussed that the CGPDT is appointed under Trademark Act. And we consider that controller as a controller of patent under this act. Then
Sir, the screen is not shared, so I can't see the what
this is not shared.
screen, sir.
I think I've shared the screen. Anya. Is it visible to other people?
Yes, it is visible.
Yes,
Okay,
sir.
sir,
It's
maybe some issue in my side.
Yes, please check. Okay. So now Patent Office and establishment, we have discussed the 73 in start that there is a Controller General of Patent, and the Controller General of Patent can have other officials who will discharge under the superintendence of the superintendence and direction of the controller. Then without this, what controller can do? Controller can assign the work to other officers, and he can withdraw any matter pending before any officer. And either he himself can do it, or transfer to someone else. And it can start from beginning or from the stage where it was. It depends all on the controller. 73(4) talks about it. See, in the MCQs, if you see the procedures and the understanding of Patent Office is coming. And sometimes if you go for 3 marker questions, you will see that they are talking about a single concept, and there are various true and false statements in one go, and you have to identify all the true answers there, especially in the 3 mark question. So please, whenever you are reading a procedure, read it carefully. Then comes Patent Office and its branches. There shall be an office that we have said that there will be a patent office, then central government can have other offices, there will be a seal, everything we have read and understood. There shall be a seal of the Patent Office 74. Then comes restriction on the employee of the Patent Office. This also we have discussed that all officers and employee of the Patent Office shall be incapable during the period which they are holding their appointment. Till they are in employment with the Patent Office, they cannot take direct or indirect interest in any patent, except that they are getting it from the inheritance or bequest. Now, officers and employees, then they say that any person will not disclose any information or assist anyone in preparation of document required under the Patent Act, or conduct any search in the record of the Patent Office, except when such act is authorized under this act or under the direction of central government or controller or by the court. So this is with respect to the Patent Office and the register. Now, suppose controller has made a decision. If your controller has made a decision and you are not agreeing to it, you can appeal. Appeal will lie in High Court. No appeal lies from any decision, order or direction of the controller or central government under the Patent Act, except as provided under the section 117(a)(2). So all controllers are in the branch office from where you are disagreeing, their high courts have the jurisdiction. From Delhi, you can go to Delhi High Court. From Mumbai, you can go to Mumbai High Court. From Chennai, you can go to Chennai Madras High Court. And if you are in Kolkata, you can go to Kolkata High Court. Now, appealable orders. Which orders can be appealed? There is a list I have given you. And as I told you, if you are learning the sections and this title, you will remember it. However, if you want to remember just the number of the sections, there is a trick. I'm just explaining it. Okay. See, 15 to 20. This is the power of controller. 15 to 20, all the orders are appealable. Then comes 25, that is opposition, we know. 25 plus 3, 28, mention of inventor. Now, in general, it will be plus 3 addition with a starting point. And you can remember like this. In bracket of 20, in bracket of 20 to 30, in bracket of 30 to 40, in 40 and 50 to 60. This, if you remember like this, it will be easy. So the first appealable order is 15 to 20. Then in 30, 20 to 30, there are only two. 25 plus 3, 28. If you remember 25, you will remember the 28. Opposition orders are appealable, so you might not need to remember the starting point here. Then 30 to 40, no. 40 to 50, no. From 50, then from 50 it starts 51 and it continues 51, 54, 57, 59. Okay, now 57, 60. You add 3 and you will get everything. 51, 54, 57, 60, 63, and then go for 66 and 69. There is plus 1, that is 61. So if you remember 51, you can remember that 51 plus 3, if I go till 69, I am safe. 70 to 80, there is only one, 78. Within 80, this series start from 85, 85, 88, 91, 92. 91, 94. And only two are the exceptions. One is 84, another is 92. Okay. So you can use this for just remembering the sections and appealable orders. Then comes appeal procedure. Every appeal shall be made within the 3 months. This is a limitation period. After 3 months, you cannot appeal that particular decision, order, or direction. Every appeal shall be in prescribed form and shall be verified in such manner as may be prescribed and shall be accompanied by copy of decision, order, and direction appealed against and by such fee as may be prescribed. Please remember the appeal procedures and this prescribed form will be governed by the rules of that high court where you are appealing. Now, few high courts have established IP division as well as created rules for that. 2 high courts are Delhi High Court and Madras High Court. And Madras High Court in IPD rules 2022 were notified on April 5, 2023, while Delhi High Court rules were notified in February 24, 22. So in these 2 places, IP division is working as per these rules. In other high courts, also IP division is working, but in the general rule of their high court. Not any specific rule has been passed till date, as per my knowledge. If you find that there is any other rule formulated by either Mumbai or Kolkata, please update us. Anyways, appearance of controller in legal proceeding. See, 117, there are only 2. One is 117A and 117E. These are the only 2 sections. Rest have been deleted. So appearance of controller in the legal proceedings. Controller has a right to appear and be heard. When in High Court, the relief which is being sought will alter and rectify the register. Please remember, controller is what? Controller is a custodian of the register, like a registrar. So he is anything which happens with his register or his practice of patent office, he will be called. He is responsible for only these two things. That's why his relief includes alteration or rectification of the register, and relating to the practice of patent office, he has a right to appear and be heard. If in appeal, the High Court from an order of controller on application for grant of patent, which is not opposed, and the application is either refused by the controller or accepted by him, subject to any amendment, modification, condition, or limitation. If there is an appeal, then yes, he has a right to come. And when there has been opposition to that, the controller considered his appearance, then controller will see if he has to appear or not. Now, unless the High Court otherwise directs, the controller may, in lieu of appearing, he does not want to appear, he can always send a statement in writing, and that's how it works. In writing, what will he say? He will give the particulars of the proceeding before him, grounds why he has made that decision, the practice of patent office in such cases, or any other relevant any other information which is relevant to the issues, and he has the knowledge of it. Okay. Now, this is happening. This is what appeal and register was there. Now, we have discussed the common format for proceedings. Common format for proceedings were nothing but this simple thing. I'm just repeating it. If you are opposing anything, you just go for a notice. You give a notice to controller. Interest, ground, and evidence is given. You give a notice to applicant whom you are opposing. Within 2 months, the applicant in general gives a reply to that and contests it. And if he contests, he has to tell the ground of contest, evidence, and copy should be sent to opponent. Within 1 month, opponent should reply, and his reply will consist of statement, evidence, and the same reply should be sent to the applicant. Now, if there is any evidence with the leave of controller, further evidence can be given. Now, then after completion of presentation of evidence, I think it should be more visible now. Much clarity. Further evidence you can submit with the leave of controller. Completion of presentation of evidence. Once the evidence have been submitted, hearing can be scheduled, and this notice of hearing will be given to you at least 10 days before the hearing is scheduled. Now, and this is if you are requesting for a hearing, notice to be heard plus fee has to be paid. Then once you have done, hearing is there. Suppose you got a new publication, you want to rely on that, please share it with 5 days. Notice to the publication or with publication. Notice along with publication should be submitted to controller and other party at least 5 days prior to the hearing. Otherwise, it will not be considered in that hearing. Then once a hearing is done, controller makes a decision and that decision is notified. This is in general the opposition, how the opposition of every opposition proceeding will work. Okay. Now, we are saying that this is applicable to post-grant opposition 25(2). When we are requesting under section 28, mention of inventor, this is applicable. If we are giving a directions to co-owner under 51, it is applicable. Amendment of application and patent is being opposed under section 57, this will be applicable. Opposition to restoration under section 85, it will be applicable. Surrender of patent 87, this is applicable. Okay, fine. let's see what else we are going for. Now we will discuss the pre-grant and post-grant opposition. Before that, I will just tell you how many sections we have continually finished, just for a quick revision, and you understand that what has happened. Definitions, we have more or less covered. 3, what are not inventions, we have covered. 4, invention related to atomic energy, we have done. 6, applicant. 7, form of application, we have done. 8, information undertaking regarding the foreign application, we have done. 9, provisional and complete specification, we have done. 10, contents of specification, we have done. 11, priority date of the claim of the complete specification, done. Publication, examination of application. In this chapter, we have done 11A, publication. 11B, request of examination. 12, examination of application. 13, search of anticipation. 13.1A, 13.1B, as well as 13.2, which one we have discussed. In a prior publication and prior claiming concept, we understood here. 14, consideration of report of the examiner by the controller, we did. Then 15, power of controller to refuse, require, amend application. 16, power of controller to make order with respect to divisional application, we did. 17, post dating, we talked about here. 18, we talked about the anticipation, how anticipation will be dealt. Then 19, we talk about if potential infringement is found during the application stage, what will happen. And 20, how the substitution of the applicant will be done. Right? Yesterday we discussed this. Then 21st, the time to make the order grant of how this application will be put in order for the grant. That we have in 21. Then 22, 23, 24 doesn't exist. We come to 25, present position. 25.1, 25.2. There are two main sections. Then 25. First thing is 25.1 talks about the ground of opposition of the pre-grant during the application time, and 25.2 talks about the grounds for post-grant opposition. Now, the pre-grant opposition, post-grant opposition, there is few differences. I'm just highlighting, and I will just take it through this, and then we will go for the opposition procedure, how they differ. First, grounds are same. Grounds are same. So you don't have to worry on those parts. You remember one ground, you will remember for others. They are as it is. In one, it is said that applicant, and in post-grant opposition, you will be referring patent. Now, pre-grant opposition, who can file it? First is when it happens. It happens pre-grant opposition before the grant of patent. Post-grant opposition after the grant, before the expiry of 1 year. Please remember these two differences. When. Then, and after that, if suppose after that you want to oppose a patent, which proceeding you will take? Revocation. Then you have to go for revocation. So pre-grant opposition, post-grant opposition. These are the two things. So any person in pre-grant opposition, you are making a representation because you are representing. That's why it is called representation. While post-grant opposition, it is called notice of opposition. So if you are writing, please remember, when you are writing for in pre-grant opposition, use word representation. While in writing for answer for post-grant opposition, use notice of opposition. Okay. The form which will be used is Form 7A. 7A is for pre-grant opposition and Form 7 is for post-grant opposition. Now, grounds are what? Grounds are, first is the wrongful obtainment of the invention. What is wrongful obtainment? Wrongful obtainment is that you didn't have a right and you have applied. That is wrongfully obtained. Wrongfully obtained invention and wrongfully obtained patent. So if you have been granted a patent, then you have wrongfully obtained the patent. Otherwise, it's a wrongfully obtained. You didn't have a right to apply and you have applied. That's the wrongful obtainment of the invention. So this is the first ground from where it starts. Then we for the anticipation by prior publication in patent applications in India. Second ground is related to anticipation of publications in India, patent publications. Then third ground is anticipation by prior publication anywhere in India or world, except the patent documents. Okay. Then comes here, exception will be there of 29, which we have. There was an exception in 29(2) and 3, where we talked about if someone has filed it, someone has used it, or someone has published it without my knowledge, and I can prove it that it was published without my consent, and as soon as I got to know about that publication, I have filed this. And if there was any use, that use was with my consent for reasonable trial. If it is not so, then again I am taking a defense that it was without my knowledge and I have not given the consent. So this is the anticipation. This is the anticipation issue which will be addressed here by prior publication. Then another one is prior claiming, right? Same thing. Whatever the language is, it's as good as same. That the invention so far as claimed, the invention as so far claimed of the complete specification of the complete specification. Hence, remember one, you can remember this. This is applicant's claim, either the claim of patentee. This is the simple, only a change because that is a post grant, this is a pre grant. So, first is wrongful obtainment, second is the anticipation by prior patent applications in India, then prior published document anywhere in the world, including India, anticipation by prior claiming by a later published specification. Now, go for if there is a public knowledge, a public use before the priority date, that will also take over your anticipation. So all your anticipation related understanding comes here, and those are the grounds. Then comes, there is an explanation to the process, and I believe we have discussed this also. See, process you cannot import, right? If you are not doing anything in India. But even if you have taken, you have brought in India, imported in India, the process, the patent product produced by that process, then we will consider is that it was disclosed. Now, same thing, obviousness, inventive step. Till this, you were discussing the novelty part. You were claiming that this invention is not novel. Now you are claiming they are not obvious, they do not involve any inventive step, and they were used in India before. Now, not an invention. Section 3 and 4 objections. Again, you can take an objection there. Insufficient, unclear disclosure. Now, claim related problems. That claim, the complete specification does not sufficiently and clearly describe. Then procedural related objections. Section 8 was not filed. The information furnished was false. Then if it is a convention application, procedural lapse. Here we are talking procedural lapse. Procedural section 8 lapse. Then from convention application, you have not entered in India within 12 months. Then we are talking about the biodiversity, the geographical origin requirement, right? With respect to biological material, non-disclosure or wrongful mention of source or geographical material. That is also a ground of this. So all those, including anticipated by TK or any community anywhere in the world. Again, in anticipation, we are talking about same thing, knowledge, oral or otherwise available within a local or indigenous community in India or elsewhere, and dispose of such representation. This is the ground. Okay. So you don't have to, you can classify in this, that one is a wrongful obtainment. You have done something fraud, you have done something wrong, so you should not be entitled to get the patent. Then you fail to meet the novelty criteria as per these 5: prior publication, prior claiming, prior use, Okay, or anticipation by traditional knowledge. Then comes obviousness, inventive step. You are not satisfying that. Then you are not a patentable subject matter. 3 and 4. Then comes claims. Not sufficient declared, not clearly described, not sufficiently disclosed. That one. Then we fall back on the procedural requirement. Section 8 requirement is not fulfilled. Convention 12-month requirement is not fulfilled. Origin and biological material disclosure is incorrect. So all those are the procedural requirements which was there. Done. So on basis of these, you can always go for the opposition. Now we will go with the flow chart to understand how this pre-grant and post-grant opposition works. So this is a pre-grant opposition. So pre-grant opposition, it talks about that opponent. Any person can be opponent. Before grant, after publication, you have to file a representation form 7A, give a statement, evidence, and request for hearing. Ground is 25(1) we discussed. You gave a representation to controller. Okay. After controller has seen this, if he has received a request for examination, okay. If he has requested the request for examination has been filed, then only he will consider this. So after publication, you can file it, but request for examination should be filed before this is considered. Otherwise, your opposition does not make sense, right? There is no need to consider it. This is a common sense. So that will be considered only if the request for examination is filed. What will happen if request for examination is not filed? Hello? What will happen if request for examination is not filed?
So it will not be examined and it will be seemed abandoned by the registrar.
Okay, now this is correct. Okay, the application is will be deemed abandoned or withdrawn.
Withdrawn.
Request for examination is not filed under 11B. It is considered as abandoned or withdrawn. It will be considered as withdrawn, not abandoned. Okay. Then comes, so this confusion will always happen. I also got confused, so I have to check. Okay, next, consideration along with examination report. Only if request for examination filed, consideration along with examination report will be sent to who? Will be sent to this applicant. Right. So with examination report, I have considered it. I found that there is a merit. I will send this to notice. I will notify to applicant. Now applicant, along with this FER, he has to reply. He will reply to my notice of this pre-grant opposition within 3 months. The reply by applicant will be statement, evidence, and copy to opponent. He has to send the copy to opponent also. Same thing. Remember our work when there is a position, how it is working. Notice to applicant. After that, reply is filed, and then hearing happens if requested. Hearing if requested within 1 month from the completion of the proceeding. After hearing within 1 month, the opposition, either opposition representation is rejected. Opposition representation is rejected, or amendment is required in the claims, or patent is refused. Depending on what is the outcome, these are the 3 outcomes which will happen. Now, we already know that there is a 6 months in between which no patent can be granted after publication. So this is the assured period of given to public to go for pre-grant opposition. Please remember, anyone can appear, anyone can oppose. Okay, and fees, there is no fees. Now comes post-grant opposition. Any person interested can only approach after grant before expiry of 1 year from the date of publication of the grant. You can do again notice of opposition. Please remember, this is a little different. Notice of opposition, form 7, statement, opponents interest, facts and relief. Opponent's interest has to be told because any person interested, only he can file. This is how opponent's interest, facts and relief has to be provided. Then comes ground. Under section 25(2), it has to be mentioned. You have notified, given the notification to controller will, and copy of this controller will notify the patentee. However, as an opponent, you have to send a copy to the patentee along with the notice of opposition filing to the controller. Now, controller notifies the patentee with copy of a statement and evidence by opponent. At the same time, he will also constitute an opposition board. Opposition board will constitute of 3 persons. 1 will be the chairman and 2 will be the members. Examiner who has examined your application cannot become the member. Okay. Any other examiner can become the member. Why he will not become a member? Because there will be conflict of interest. That, since you have already seen, you might be biased towards your own findings, not towards the applicant, towards your findings. Now, notify the patentee with the copy of a statement and evidence by opponent. Now, either you will reply to contest or you are not replying. If opponent is not replying, it will be abandoned. I'm very sorry. Within 2 months after the patentee has been notified, if patentee does not reply with written then it will be considered as abandoned and revocation order will be passed because patent is existing. If he replies and contests, then the grounds and evidence he has to tell, and he has to send a copy to opponent. And within 1 month from the date of delivery of the reply, opponent needs to file the evidence with a copy of applicant, copy to the applicant. Evidence is filed on the basis of affidavit that you solely and affirm that this whatever I'm saying is true, and all those will be considered as an affidavit as good as filed in a court. Now, no further evidence except again what we have discussed earlier. If once opponent has given evidence and applicant has given evidence, after that opponent is given another chance to file a further evidence, and once this is done, no further evidence is filed except with the leave of controller. Once all the evidence has been gathered, hearing notice will be given and hearing will be scheduled at least 10 days from the date of notice. Before and now, before the hearing, what will happen? Why the examination board was constituted? Examination board will be forwarded all this document which is being received. So he will, the examination board will what to do? Will receive the notice of opposition, reply of evidence, and further evidence filed by the opponent, and any other evidence or other document which has been submitted. From the date of last document received, within 3 months, they will give a joint recommendation to the controller. Along with the copy, this controller, then this recommendation will be given, sent to the parties along with the hearing notice. After hearing, same thing. you will revoke, amend, or refuse. Okay. I think that will mark the end. That's it. And if you want, we are asking that you have to amend the patent, a reasonable time will be given to you so that you can amend. Same here, hearing request, new publication we have talked about. I have already told you this. Same thing is here. Hearing on request. Hearing will be on request and new publication. If you find, you have to tell them 5 days, at least 5 days before the hearing date. You cannot introduce any other publication before that. After that, this was the entire 25 section in which pre-grant and post-grant opposition. Okay. Now, suppose there was a wrongful obtainment. 25(1)(a). What will happen? In pre-grant opposition, if you have opposed, it will be considered that you have claimed the invention as that this has been wrongfully obtained, and it will go through the same proceeding as in the pre-grant opposition has been prescribed. What happens when you have approached in proposed grant opposition, patent was granted? What will happen? Then, see, this is a little incorrect. It should be this is 25(2)(a). So in 25(2)(a), what happens is wrongful obtainment was there and you went for the revocation. तो अभी इसको ऐसे समझिए. Suppose you are the person whose invention was taken away. So what option you have? If you got to know it during the application procedure, then you can directly go for opposition, a pre-grant opposition, as well as you can file your own patent application immediately. Okay. You will say that you are not entitled and I am entitled. And this is how you will defend your invention. Suppose you got to know it later when the patent was granted. Now, then you will fall under section 26. First, you will oppose it. After opposing it under 25(2)(a), there will be that this is revocation. If it is wrongfully obtained, what will happen is invention will be revoked. But there can be a situation where part invention has been taken away, not the entire invention. And if I remove that part of invention, invention can survive. Then what will happen is that part of invention will be asked to be amended so that patent application survives. So this is how it happens. So if this is wrongfully obtained, entire invention, then revocation order is passed within 3 when it will be revoked because your entire invention is having this. Or if there is a part invention, then what will happen is the other party will amend it and exclude the wrongfully obtained part from this complete specification. His patent application survived. At the same time, you also applied for the patent application for the invention too. That means you also want the application for your invention. So there can be 2 scenarios. That either your invention is the entire cut part, whatever you have got, that is your invention, or there is something more than that. The whole or part is there. Okay. Then what will happen is obtained part will be deemed as okay. So I think it is getting more confusing. I should take you to Excel sheet so that it's easier. मैं समझेगा नहीं. Suppose there was an invention has A, B, C, D part. Okay. This is the invention. If you have all the, if all parts of invention is yours, wrongfully obtained, then it is revoked. Okay. Once it is revoked, what you can do within 3 months, you can file and ask this patent to be amended in my name. Because this is yours, you have already proved it. You have already proved in a position proceeding that this is yours. And the patent entire invention has anyway qualified for novelty, invention, and other steps. So this patent, you will say that transfer it, substitute my, put my name into it. So opponent can get the whole invention. This much is fine. Okay. And controller will also. Which form you will use? Form 12. Right? Just a minute. Form 12. 12 baj gaye. Right. This type of. So you are using form 12. Form 12 is used in wrongful obtainment when someone else who is claiming that who has got the patent revoked and wants his name to be included in that patent. The form 12 is used. Now, suppose this is first scenario. Suppose it was decided that CD is your part. CD is wrongfully obtained. Okay. So, and after taking it out, AB can survive. So if AB is amended, then AB will become, it will be amended. So AB will have this will be as a invention for 1, for which patent was granted. So this patent will remain as for AB only, not for CD. What will happen to CD? If you have, suppose you also wanted I will also go for patenting, and you applied for CD, or you can apply for CD plus EF, right? So there can be a chance that this is the only invention for you, or this is invention along with someone. If this is the only invention, then same thought will apply. You can get your name written here. However, when it is there, what will happen? If you succeed that your invention is done, then what is the date of how it will be checked? What date will be deemed to be filed? So they say that whatever was the obtained part, it will be deemed as, its priority will be deemed as a date of filing of the earlier invention. Okay. CD was stolen. It's a stolen part. A stolen part will be considered that deemed as filed on the date of filing of patentee in a relegation. The filing date of patent 1. And EF will be treated as filed on the date where patent application 2 was filed, or patent 2 was filed. Okay. Is it clear? Any doubt? Any doubt here?
Sir, for CD, the date will be the filing date for ABCD, right?
See, yes. This
Sir,
is the first patent.
Yes, sir.
This
Yes,
is the
sir.
patent. So when it is amended, it remains as a patent 1, because after amendment, patent 1 survived.
Yes, sir.
Right. So if I don't take this filing date, what will happen? This patent 1 specification, which was wrongfully obtained, will anticipate my invention, no? Right?
Yes, sir.
So I am a sufferer. My stolen thing should not harm me, right? That's why this is how it is. The filing date of patent 1, it will be considered as filing date of patent 1. While for EF when we are doing, then we will consider that this EF is with respect to date on which this patent 2 was filed, because this is the new part. Hope this is clear. Any confusion? Okay. So this is how under 26 you have asked for the for your name to be included to the controller. You have requested directly to the controller. However, there can be another situation. You went to 52. 26, double it, 52. Then it again talks about the wrongful obtainment. It says that if an invention is obtained by fraud, so I'm just relating it with the wrongful obtained by fraud, then true and first inventor, TNF, right? It was wrongfully obtained in contravention to TNF, right? Then what will happen? During the court proceeding, it can be a court will ask that exclude the obtained part. Then your patent can survive. This is the only way. So, and whatever the excluded part, for that petitioner can get a grant in a whole. Court can directly grant it, or grant the petitioner the part which has been excluded. There also patent can be granted. Okay. So if that is the court order, within 3 months, in Form 12, you have to request to the controller that this is a court order in which I am entitled to this kind of a patent. A statement of your request will be a statement of the fact, as well as the relief you will seek, and the certified copy of High Court as an evidence will be produced before the controller. All this should be filed along with your Form 12. The controller will look into it and either give you a grant of new patent. This new patent, which is that it is bearing same number and date. That is the obtained patent. When it is happening, when whole was yours. When it was part, then for part, you will get a new patent and the number will differ. Same series, same day as obtained, patent was granted. It will be same series and same day. But here it will be same number and date. So this is the difference. In the last, what is happening? What was stolen is giving back to you with the same entitlement as it was given to the other party. That's how it is being restored to you. Okay. Now, there is another concept, it's called mention of an inventor. Mention of inventor is pre-grant proceeding. It is in 28.3. 28, what it talks about. Suppose there is a true and first inventor, he has not been mentioned as an inventor. Please remember, if you are becoming an inventor, if your name is being included as an inventor, you are not getting any right. So while writing, there was a question earlier also. Few people have answered it that inventor should be the other party. This wrongfully obtained was the question, that someone has taken someone's invention and filed for the patent. What is the remedy you will suggest? Few people suggested that mentioning as an inventor should be the remedy. Please note, mentioning of the inventor as a remedy is not helping him anywhere. Why? He is not getting single right. Inventors don't get right. Only the applicant gets the right. So mentioning as an inventor will not help him anywhere. However, why inventors are being mentioned? If someone is claiming, the inventors are mentioned because that is the acknowledgement of their work. Few research scientists or every scientist wants to get the recognition for their work. For recognition of their work, the mentioning of inventor should be done. However, if you want that person to acquire the right, he should be the applicant, not only the inventor. So please remember this difference so that when you are suggesting a remedy, you suggest the remedy accordingly. Now comes the mention of inventor. Before the grant of patent controller, there are two major things. This section 28 deals with if you want to mention yourself as an inventor, or if you think you have been wrongly mentioned as an inventor, you can ask for your removal also under the same section. 28.7 deals with the unmentioning of the invention. Then what is happening here? Again, I will go to Excel sheet so that you can understand better. Let's understand how many scenarios can be there. True and first inventor, we missed it in a good way. We never wanted to miss him. We later remember that he is also inventors. We got to know and we wanted to mention. Suppose an educational institution was there. He filed this application with two people. By mistake, by some mismatch of the documents, or by any clerical error, only two people were mentioned as an inventor. So if in this scenario, anyone wants to become an inventor, what will happen? Applicant plus the PNF whose name has to be mentioned. These both can go for request. They will request for the addition of this name. Okay. However, if there is TNF, an applicant is not in cordial relation with this, then he has to claim on its own. The moment TNF claims, he is considered as claimant. Now he is not a requester. Okay, so this is now becomes his claim. Now he is claiming to become to be mentioned as an inventor. Okay, so these are the two scenarios. One is this, another is this. Done. Let's take it with the red. Okay, so now you can understand. So it is a request and a claim. Now we go back to this. So under 28.1, 28.2. When 28.2 mention arguments, applicant or 28.3. This is the format is filed. 28.2 and 28.3. 28.3 deals with the claimant. 28.2 deals with the applicant. Sab raji khushi hai. Everyone is happy. Then 28.2. Otherwise 28.3 claim. Okay. In either scenario, if applicant and TNF person interested is being thus, you have to notify who? All the other applicants will be notified. If there are other applicants, all other applicants should be notified because they are the interested party here. Here again, all applicants will be notified because someone is claiming to be included in your patent. All applicants will be notified. Right? That's all. Then comes the understanding. We are considering mention only at present, not 28.7. We are not talking about it. inventor of invention, substantial part of invention, or whose name will be included, this should be there. Either you are invented, or you have invented substantial part, or you are the invention is the direct consequence of the action of your claimant. Okay, then only you can be added. So request for mentioning in format is filed. Request or the claim. Okay. So if request is there under 28.2, if there is a claim, it is under 28.3. If he is claiming, there will be a request plus statement of the claim has to be given in format. Before the grant, it will happen. What will happen again? Then notice will be given. Notice will be given in the case of this, and request will be here. This is what we are talking. The notice was sent to who? Every other party who is interested. Then written statement and reply has to be filed by those who have been notified. If there is a reply, then claimant will have a right, or the applicant will have the right to reply to it. If there is still a context, hearing will be done. After hearing, order will be passed. Same procedure as we have discussed earlier. Okay. This was 26 we have completed. Sorry, we have completed 28. 25 we have done. 26 was the wrongful obtainment. Then 25 was the opposition. 26 was the wrongful obtainment. 28 was the mention of inventor. 27 is missing. After that, 29 to 34, anticipation we have already discussed. Then 35 to 42, secrecy direction we have already discussed. Then 43 to 53, grant of patent and related rights we have already discussed and finished. Then patent of addition 54, 55, 56 we have done. Now we are on amendment of application 57 to 59. Let's go to that. See, amendment of application and specification. 57 talks about how amendment will be done with the permission of controller. 58 talks about how amendment will be done with the direction of High Court. And 59 talks about what can be done in the amendment. Now 57 key points are simple. Amendment can only be brought by the way of disclaimer, correction, and explanation. No third part. That means either you can disclaimer, you have to disclaim the invention by delimiting the claims. This is the first line, that you have to narrow down your invention. Then you can amend. You are correcting a clerical error and mistake. That can be done. You can add explanation. But when you are adding the explanation, you cannot change the scope of the invention. You are explaining, but you cannot broaden the scope of your claim. The most important part is this. The moment you go for amendment of application or specification, this is how it will happen. Amendment can only be for the incorporation of the actual fact. No amendment of complete specification which broaden the scope of claim can be introduced. No amendment shall be allowed if amended claim is more than the scope of earlier unamended claim. So what is happening is you can narrow it, you cannot broaden it. So this is the restriction on amendment. Then originals can be used for construing amendments. Post grant amendment can be allowed by controller or High Court. Okay, how? The amendment will be allowed when amendment shall be for all purposes deemed to be part of. Once the amendment is done, it will be considered as a part of a specification. Then the fact that specification of the document related thereto has been amended shall be published. After post grant amendment, you have to publish the amendment. and it will be open for the opposition. Anyone can oppose this amendment. The fact the specification or any other documents related thereto has been amended shall be published as expeditiously as possible. Same thing. Then right of applicant or patentee to make amendment. This cannot be called in question unless they are committing a fraud. So this is the key point of amendment. Now we'll go to amendment proceeding. Before controller, how it will be amended? Any applicant, see, during the phase of application also you can amend. But if you are an applicant, you will go only before the controller. So that's how it happens. You will take a leave, application for leave to amend. You have to file form 13. You file a form 13 for the amendment. Form 12 is for if you change of the name of the wrongfully obtained patent in name of the person from whom it was stolen, right? So application for leave to amend form 13. In form 13, what we are talking about is nature of amendment and reason of amendment. This you have to tell. Right? Once you have told before grant, it's very easy. Before grant, it's very easy. Controller does not have to tell anyone. He will look into it. Controller will determine, refuse, allow with the conditions. This is how it is. However, after grant, it has to be published. It will be published, and this will be published if the proposed amendment is of substantial nature. If there is a clerical error, he will not publish it. But if it is a substantial error, the claim has been brought in or explanation has been added and it has a substantial effect, publication will be done. And in 3 months, any interested person can oppose. And notice of opposition, he has to file a notice of opposition, form 14, to the controller, and then all that proceeding which we have discussed, notice, then reply, and then evidence, then filing, then hearing will follow, and the consequence will be either he will refuse the amendment or he will allow the amendment. Once the amendment allows, it will be published with the allowed amendment. This is the amendment part. Now go to the controller work is done. If in High Court, what happens in High Court? In High Court, in revocation proceedings, there can be a situation where High Court is allowing you to amend it. The patentee himself says, okay, it's better to get better to protect my patent by amending it. So you are allowed to amend subject to the terms, cost and terms, including cost and advertisement. You are allowed to amend. Or suppose High Court decides that it is invalid, but on the plea of patentee, instead of revoking, allows the amendment. High Court says, okay, you can amend. If that is done, then you have to file application to High Court for amendment. Once the High Court has received your amendment notice, that will be transferred to the notice that will be given to notice to the you will file for the application in High Court for amendment. At the same time, you will give notice to the controller also for the same thing, that I am applying for the High Court to High Court for the amendment. Now, controller has a right to appear and be heard because something is getting altered in his register. The controller will come, appear and hear it, and High Court will allow High Court, after hearing controller, High Court orders to allow the amendment. Then controller will cause that entry and a reference of that amendment that this High Court order has been done. Because of this all things have been done. Okay. So this is the amendment proceeding. We have completed till this was 758, right? Yes. We have completed 57, 58, 59. Okay. There are 2 sections which are left. One is 44, I have not discussed. Another is 50, 51. Okay, 50-51 is related to the co-owner right, but since time is less, I will not be discussing it. And at the same time, another one was 44. That is, if an applicant dies, how that happened, that we will see tomorrow. Not a. Okay. Now, before we leave, let's go to the e-register part. You can access e-register here. Any granted patent, if you enter, you can go and see the view application status. Here you can see the e-register. Now see what is the how the e-register looks like. It says the legal status is in force. Due date of next renewal is 24. What kind of application it was. When date of grant is this. And date of recordal is same. See. Date of patent is the date of filing date of that particular patent. 31/7/2014. Now, which office it is dealing with? Kolkata. In PCT, international filing date was 31/7/2014. Same is the filing date of patent. That is the date of patent. So you can be asked this question: what is the date, or what is the difference of date of patent, or date of recordal, or date of grant? Please understand, filing date becomes the date of patent. Date of recordal is the date on which the patent has been recorded in the register, and patent is recorded on the date of grant in the register. So date of grant and date of recordal are the same thing, but refers to a different action. Patent granted, the patent was granted, the order was passed, that is the date of grant. It will be recorded on the same date in the register. That's why it's called date of recordal. Now comes title is here. What title has been granted? This is the name of grantee. See, grantee is different. Patentees are different. So grantee, and then there is a patentee. Then there is an address of service. Then priority date has also been mentioned. Now, regular payment of renewal fees. Working of patents, they have not filed. So we cannot see it here. No record form. Or filed or not, might not be that they have not uploaded. But when we are working of patent is filed, this is how it looks like. It is with respect to NTPC Limited. It clear cut says, this is my patent number. They are explaining, being used, practiced at a pilot level NTPC Dadari. At present, it is difficult to evaluate the revenue value accrued using the patented answer. Licensing opportunity is also being looked at. This is, they have submitted for 22-23. Okay. Submitted on 27 September of 2023. Before the expiry of September 2023, you should submit, because fine before the it should be submitted in the beginning of the financial year, before the expiry of 6 months of the financial year. That's what it is. By this is an ordinary plus. This is 2023 application. Obviously, there will be no patent. Working will not be there. Right? Grantee, patentee, and then date of renewal and other things. This is the information under section. Working of patent is also found. Fine. So all this is completed.